celebrating Constitution Day. Yesterday, the Constitution was 220 years old. Dr. Laker from Wheeling Jesuit University is here to help us celebrate by reviewing the book, Supreme Conflict, the inside story of the struggle to control the U.S. Supreme Court. Dr. Laker's been a professor at Wheeling Jesuit for many years. He taught both my wife
It's not
and
my way.
myself many years ago.
Do you want to sit here? I can sit
No,
down.
no, I've got to stay close to this. Somebody will trip.
Please
Thank
welcome
you.
Dr. Laker.
Thank you. I'm not going to use the microphone. I'll just try to yell it out, and if you can't hear me, let me know. I'll try to speak up loud. The book here that I'm going to review by Jan Crawford Greenburg primarily talks about the struggle for control of the Supreme Court between those of the right and those of the left, and how this struggle has become exceedingly intense in the last 20 years, especially since the nomination of Robert Bork in 1986. But actually, contention and struggles over the Supreme Court go right back to the very beginning of the country and the signing of the Constitution. The second president, who was responsible for the appointing of John Marshall, made some midnight appointments right before he left office to make sure that Federalist judges would be on the Supreme Court because the Federalist Party has lost the election, and he wanted to have some way to affect the future of the country. The incoming president, Thomas Jefferson, immediately tried to prevent the seating of these justices, and the issue went to the Supreme Court, and there Justice Marshall sided with John Adams. And so these justices were seated in any case. So right from the beginning, there was trouble between political parties struggling to control the future of the court. And this occurred again in Thomas Jefferson's time, Andy Jackson's time, Abe Lincoln's time, Theodore Roosevelt, FDR. FDR was well known for his court packing scheme when the court rejected a number of his pieces of legislation. He decided he would expand the court dramatically. And this brought about intense opposition by people who felt that he was overstepping his bounds, that the Constitution had been set up to balance executive power against legislative power of Congress, House and Senate, versus the judicial power, and that each branch should be somewhat independent of the other so that they could check one another's power and preserve liberty. Abraham Lincoln got a chance to appoint 5 justices and was very interested in making sure that the court would follow, let's say, the kind of policies that he was in favor. But he pointed out that, when you bring a justice up there, it's often best not to press them too hard on particular cases. And so I wanted to read a little comment that he made back in 1863 when he appointed his Secretary of Treasury to the Supreme Court as the new Chief Justice. And he said to a friend, we wish for a Chief Justice who will sustain what we have done in regard to emancipation and legal tenders, meaning the financial system of the time. We cannot ask a man what he will do, and if we should ask a person, and he should answer us, we will despise him for it. Therefore, we must take a man whose opinions are known. So, he was saying we've got to carefully vet our nominees to make sure that they will follow and provide the kind of opinions that we hope that they will reach, rather than ask them about particular cases. And generally, throughout most of the history of the Supreme Court, there has been real attempts to prevent litmus test questions when justices come before the Senate for their confirmation hearings. So the president gets to nominate, but it is the Senate that must confirm Supreme Court nominees in their position. The position is lifetime, so that once you are on the Supreme Court, you will stay until you retire or until you die. Most justices resign before they pass away, but there are some who stay right to the end, including the last Chief Justice, William Rehnquist, who wrote a book in which his last chapter talks about presidential appointments and controversies. So this has been an issue right from the beginning. And I first became aware of this book when I read a rather long review about the book, and I thought, wow, this is really an interesting topic, and the review was quite positive. And so then when I got the book, I found it a very easy read. This is a very enjoyable kind of read. And it provides, one of the things that I liked about it is it tells you very much about how the selection process goes. How presidents work to sort of choose nominees that they're going to present to the Senate, how they help to prepare these nominees so that they can face the confirmation ordeal, and it is a real ordeal because they will spend sometimes weeks and maybe even months trying to convince the senators to support them. Generally, they try to see almost every single senator to persuade them to provide them with their vote. So that she gives a very good idea of the politics behind the nominations that take place. And she also talks very nicely about the different individual justices that are currently serving on the court, so that you come away with a sense of what kind of people they are, what kind of personalities they have, and what kind of pressures that they are working under. And finally, she says a lot that is very revealing about how the court actually does its job, how the different justices interact with one another, and most of the time they do not engage in oral dialogues or discussions at great length. There are those time frames, but primarily they will sit and write their opinions and circulate their opinions and then get feedback primarily by print. So I found the book very, very revealing. And one of the things that impressed me by this book was the fact that I thought this person was very even-handed in how she attempted to talk about the court. One of the key elements that has caused this tension in the last 20 years, since the attempted nomination of Robert Bork, his nomination was defeated. They then, President Reagan nominated Justice Scalia, who passed unanimous, okay? But it was only after he had been forced to pull back on Bork's nomination. But one of the things she does is talk about the philosophy of the two sides, the judicial philosophy. And I thought I'd like to read these two brief paragraphs because they sort of sum up, I think, very, very nicely. She says, liberals believe that it is entirely proper role for the courts, especially since the other branches of government fail so miserably in the area of civil rights. The court was supposed to protect the rights of the minority against the will of the majority. If judges would not, they said, no one would. That approach encouraged the justices to identify new constitutional rights, especially in situations the document's framers could never have imagined 200 years earlier. As society changed, the understanding of the Constitution should change with it, liberals believe, and the judges should help foster that progression. Okay? So that's one interpretation of the function of the court and the way in which it should interpret the Constitution and new legislation that comes before it, new cases that come before it for their education. Conservatives saw a Supreme Court that had arrogantly grabbed power for itself by deciding those issues and creating new constitutional rights. Conservatives believe the justice usurped the role of elected officials who were closer to the people and more accountable for their decisions at the ballot box. That struck at the heart of democratic participation, they believed. After all, voters agreed by their elected officials could campaign for change. But if the court's unelected judges made their decisions, the electorate had no leverage and little incentive to get involved in the debates. So, the two sort of very opposite ways of looking at the Constitution and the role that the court should play. Conservatives want a much more limited role in which it confines itself to interpreting the Constitution, not making social policy. This is the view of the conservatives. There are other elements that will, let's say, play a role in this judicial philosophy, but in terms of a quick summary, I felt this was a very nice, short little captive description of the two, and even-handed, because you can see that it depends on the case, but there are times when you might find the liberal approach appealing and perhaps even necessary, and other times where you might realize that it might contain within it certain dangers. The same is true of the conservative approach, because if you follow it to a T, it might become too rigid and not deal with problems in society. I think there are some other elements, though, that influence the way in which Supreme Court justices are chosen beside this sort of judicial philosophy. But maybe I should mention two other things on the individual, well, let's say the judicial philosophy for relieving it. One is the role that legislative history plays in interpretation. So when a bill is passed through Congress and becomes law, it has to go through both the House and the Senate. Usually, senators will make lots of speeches and put documents into the congressional record that talk about how this piece of legislation was formed and what the intention of that legislation is. Okay? So it provides a context for a particular law. The author of this book talks a little bit about how, let's say, this interpretation goes with this. Conservatives generally are opposed to having justices look at these legislative statements and that context, saying the law should be written clearly enough that it will tell people what the purpose of that legislation is. And we don't need that context. And so I want to read just this little bit so that you can sort of catch the flavor of this key issue. Most conservatives, like Scalia, believe that courts should not look to the legislative history, the debate, the pronouncements about a law when the legislature approved it, when they are trying to discern its meaning years down the road. Scalia and others believe that legislation history is irrelevant and misleading, and that the words of a handful of the most vocal legislators shouldn't carry the day. To some extent, this review is grounded in the practical consideration that the views of legislators are sometimes entered into the record well after the fact, or at the behest of interest groups that don't reflect the views of Congress. So he would say that, Scalia would say, well, we don't want to put too much weight on this legislative history because not every congressman is going to talk about it. And we don't know what the real will of Congress might be. We only know what the vocal majority will say. In addition, though, to this judicial philosophy that every justice has when they go in, and most of the people that are appointed are at least in their 40s. They might be even in their 50s. You don't want to choose one that is too old because their term on the court wouldn't last very long. So most are in their 40s. And by that time, most justices will have fairly decided views. They will have sort of an judicial framework. But presidents, I should say, not historians so much, but presidents have been repeatedly disappointed by the behavior of judges once they are on the court. That somehow they do not prove to be as loyal as they thought they were going to be. What makes them change? And we can look at some of the people that have changed. Well, one of the things that makes them change is that all the justices are aided in their work by law clerks. One of the most exciting things that if you're a young lawyer is to get an opportunity to work as a law clerk for one of the justices on the Supreme Court. You might work there 2, 3, 4 years. You do a lot of legal research for them. You do a lot of writing for them, so that when they form their opinions, they're basing their work on what you've done. And this makes a great reputation when you then go out in the world. And if you're going to work in a law firm or you're going to work in politics, you get the recommendation of one of the justices of the Supreme Court. But these law clerks often have a major role to play in the shaping of the words that the justice uses. So he will say, well, go and draft this speech or this text that will give my opinion about a particular law. He will come back with it and give it to you. But, whenever I pick up student papers and I start grading them, even if the paper is filled with things I don't agree with, I will not change most of the language in the paper. I might say, this is not very satisfactory. Here are some key things I want you to rethink and rechange. Go back and do it again. And he will tell that to, the justice will tell that to a law clerk. But the language is the law clerk's, okay? And he will be influenced by that language. So that when he writes his own, even if he's writing his own stuff eventually, he will be somewhat influenced by the language as if his law clerks. And so it depends on what law clerks you're getting. And you will get the best and the brightest young lawyers out of our best law schools. But that influences the thinking of a justice, especially a justice who might be, one might say, more open-minded than others or more wishy-washy than others. They're sort of in the middle and they can go either way. The second is the other justices, because they do have frequent social interaction and occasionally they do have discussions with each other. It's surprising that you find the people who are on, extreme, one might be real conservative, the other one very liberal. Nonetheless, they form close friendships and there's not a lot of overt hostility. There are only 9 people here, and they socially interact. They often become very good friends. And in the give and take of discussion, they might be influenced by the other justice. Thirdly, there are groups outside of the court, because these justices don't live in a vacuum. They belong to various kinds of organizations that will influence how they interpret the law in particular cases. So justices can be influenced by outside interests, not necessarily in a negative way. I'm not saying, a company calls up a justice and says, well, we'll give you so much if you, vote a certain way. That would be rank corruption. And frankly, the Supreme Court is really pretty immune from that. Because first of all, they get fairly good salaries. They make a lot more in some law firms. But still, they get pretty good salaries. They have lifetime tenure. They don't have to really worry if they offend somebody while they're writing. So they're sort of immune from some of the more intense pressures that politicians will face. But nonetheless, we're all influenced by people we talk to, people we associate with. And some of the judges have shifted. And in the book, she talks about Sandra Day O'Connor fairly a large amount of time. She certainly greatly admired Sandra Day O'Connor and said, wow, this person is really a super justice. Justice O'Connor, who was appointed by Reagan, gradually shifted more to a more liberal position, okay, on a number of key issues, not every issue. But one of the key issues that moved her was the issue of abortion, Roe v. Wade, which has become one of the key litmus tests that any justice who goes before the Senate to get his nomination confirmed will have to deal with on both sides of the issue. But part of the reason she moved to a more liberal position was that Clarence Thomas was added to the court. And when he came in, he was a much more assertive kind of justice than most people realize. So when the oral arguments come before the Supreme Court and lawyers go before to plead their case, Justice Thomas almost never asks a question. They get lots of questions from other justices, especially Justice Scalia, Justice Souter, Justice Kennedy. They're always peppering these guys with questions. Usually Justice Thomas doesn't say anything, and many people felt, well, that's because he doesn't know what he's doing up there. And he's not at all an assertive personality. That's not the image she gives of Justice Thomas here. She said, no, this is a very strong person, strong personality who has a very clear sense of what he feels the function of the court is and how that court should look at the Constitution. So that when he wrote his opinions, and then would circulate it with the other justices, frequently he would tick off some of them because he took a more assertive or stronger position than they expected. And in a few of the cases, it was an issue that Sandra Day O'Connor felt very strongly about. And she felt that Justice Thomas was carrying her, even though she might agree with him on the merits of the case, he was in his arguments carrying her far further to the right, to the conservative direction that she was happy with. So as a consequence, in reaction to that, she began to shift to a more liberal position. The same sort of thing happened with Justice Kennedy, also nominated by a Republican and confirmed. And at first first 3 years, he had a very conservative position on most issues, but once the complexion of the court began to change and began to become a little more conservative, he began to move in the opposite direction. So that once you're a justice, you got a lifetime tenure, you don't have to worry about the guy who appointed you, who nominated you, who Senate appointed you. You can do what you think is best. So when I look at what influences courts, one is judicial philosophy. Second is who you're influenced by, including other justices that might tick you off on a particular case. A third one is political considerations. Most of these people are people that are well known in their political party, and they wouldn't get to this high rank and position nomination unless people like Lincoln would say, we know where this guy's coming from, or at least we think we do. So they have strong political ties very often. And finally, the particular issue. And there is the place where you get justices going off in directions that maybe the people that nominated them would not be happy with. So to give you one example of Justice Kennedy, one of the key issues that she talks about is the school prayer issue. whether there should be sort of an absolute division of church and state, or what does that really mean. And she points out that Kennedy, during that first 3 years, staked out perhaps the most conservative position on that particular issue of the whole court, more conservative than anybody else. And then, after the court's complexion began to change, he also began to change, and he began to move to a more leftist position, and they made a decision on a particular case, and the Chief Justice said, well, you're in the majority, and you're going to write the majority opinion. So he started writing the majority opinion, and ultimately he changed his mind, and he came back to the Chief Justice and said, I cannot write this opinion. I've written a different one, and I'm now opposed to the position I took. And so ultimately the case, and he was the swing justice, so the case went against those, and it was mainly whether nativity scenes could be located in courthouses. And he first said yes, and now he ultimately said no. Okay? So he's an example of one of these guys who moves back and forth. There are some, and I'll try to end up with this because I said, I'm trying to leave time for some questions afterwards. There are some reservations I have with the book, in spite of saying, hey, this is really a good read, you'll enjoy it, you'll learn a lot about the court. She talks about dozens of different Supreme Court cases and issues that arise. And sometimes she'll talk about the same case more than once, 3, 4, 5 times in the course of the book. For most of these, she never talks about the case in enough detail that you feel that you really fully understand both sides of the case. She deals with the abortion case, the Roe v. Wade, and the attempts to modify Roe v. Wade more often than any other case, but even that is discussed on a number of different occasions in the book, and she never fully says, well, this is what one side thinks and this is what the other side thinks. And she does this in dozens of other cases that she talks about in the book, and you come away saying, well, I'm not quite sure what the full meaning of this case was, and I would have to look at another book. Of course, there are lots of other books up here, including this little one here, which I thought was wonderful. I'm not sure if that's the same thing, but it says, the 34 Supreme Court cases that most directly affect your life. And they will look at each case. So I would say that having a little handy book like this might be also a useful thing when you're reading Greenberg's book. The second is she has footnotes. She talks about books she's read, a limited number. For a 300-page book, she has about 160 footnotes, which is not very much and would not impress an academician. She's a journalist. She's not an historian. She's not a political scientist. So primarily, she bases her knowledge on oral interviews. And she's talked about a few people she interviewed, like Sandra Day O'Connor and Kerry Blackman. And she says, I interviewed 9 of the justices. Doesn't mean all the current 9, some of them are retired. She doesn't spell them all out. And she says, I interviewed about 100 different people. And I greatly admire the confidence that the sources placed in me and I place in them. But you're not sure totally of her methodology in gathering the information and saying, yeah, I know where she got that particular quote, where she got that particular insight about a particular justice. From what I can tell, though, she's spared all of them. She has admiration for all the justices. Even justices that I would say if she has a slight orientation, it's slightly to the left, but it's not overt. She's even-handed. And the one that she deals with that perhaps has gotten the hardest press, that had a very hard confirmation hearing, was Justice Thomas. And the title of the chapter that she gives was a quotation from a headline in the New York Times called "The Youngest, Cruelest Justice." Okay? But when you read her chapter about Clarence Thomas, you realize this guy is a much more complex, sophisticated individual than this little headline will give you. That his opposition to some of the cases, well, some of the positions that the New York Times would have had him take is based on true principles that he has long thought about. So, to me, this is really a wonderful book to read, a pleasant introduction to the Supreme Court. It's not one that I would say, this is the last word on the subject, but I recommend it to you. I thought I had a good, fun time reading it. And I'd be happy to sort of answer questions if I can, but I'm no expert on the Supreme Court. I've always just sort of been very interested in the court that's doing this. Yeah.
Do you know exactly, more or less, when the idea began to develop that there were certain seats on the Supreme Court, like a Jewish seat, a black seat, a female seat, a Hispanic seat, got started? And do you think that that's had a negative influence on the prestige of the Supreme Court, because people begin to say, well, you know, he voted that way because he's the blank seat on the Supreme Court?
I think actually that arose probably in the 1950s in a very limited way, but it did not become really intense until the 1980s. And partly because the first black person served on the court was Thurgood Marshall. He held that position for a long time, and the person who replaced him was Clarence Thomas, another black. So when he was leaving, the question became, we need another black justice on the court. The problem in the minds of some was, hey, there's a Republican president. The Republicans don't have a huge constituency of black justices. Who are they going to choose? And he chose Clarence Thomas. Okay, and the result was that idea arose. When the first woman was elected, the thought was we need to expand the court because there are groups in American society who perhaps have special insights and special problems that the court maybe cannot adjust to its own name. And so that it appears that we want at least one woman on the court. Now there's only one, and when Sandra Day O'Connor resigned her position, she had real hopes that there would be a woman to replace her. And the president actually looked around and thought of several women, but he was a Republican, they were going to be conservative women, and he knew that there might be a difficult time getting them to be accepted. So that actually didn't happen. Now there's only one on them, that's Justice Ginsburg. And when John Roberts came in, he was going to be his replacement, and then later on he boosted up to Drenka's position that they put in Alito. She talks about Sandra Day O'Connor being somewhat miffed. There should have been a woman who replaced me. I myself think that a certain amount of diversity on the court probably is a good thing, so long as it's not automatic that you only look among that group that needs to be replaced. So if they only looked among black justices at that moment to say, oh, we need a black justice, we have to have one, that would weaken the stature of that particular justice, and I think somewhat call into question the court's independence. I don't see that as a big problem. I see the bigger problem is the intense kind of partisan atmosphere we've had since 1986, where, now, not all justices have not been approved or almost overwhelming. Some of them have and others haven't. We live in such an intensely partisan time right now. Even if I were, a very sober judge with a wonderful record, I wonder if I would want to go through that nomination process, because people will look to anything they can find on you, and this is probably either side, and use or misuse what they find. So those people that, when they get lifetime employment, some of them have worked hard to get that position.
Could you refresh our memory on Bork? I remember what he looked like, curly hair and what have you, but what was the big stink about Bork?
Well, there were several. One of them was he was the Solicitor General at the time of the Watergate incident. And when it came time to fire the special prosecutor, he was not the highest level, but he was several levels down, and the other two resigned rather than do it. And he went and did what the president wanted him to do. So that was one strike against him. They saw him as a loyal Republican, person with strong political views. Now, that doesn't mean that other justices have not had that. More particularly, though, they did not like his judicial philosophy and his position on Roe v. Wade. They knew that if they would put him on the court, he would be 1 out of 9 votes that would definitely say that the judgment made in Roe v. Wade was a poor decision, poorly supported, and he would have gotten rid of it. But I think it was the judicial philosophy. I remember watching those hearings, and I was engaged in a debate on campus with a person that taught in the criminal justice department at the time. And part of it is we were trying to, get our students engaged in thinking about, Supreme Court and what was going on TV. And I was kind of distressed at my colleague who, in the course of the debate, basically said, well, I really don't care what kind of justice is that we choose, so long as he will vote the right way. So long as he will vote the way that I want him to vote on the key issues. And I said, I want somebody who has a principled view of the Constitution and who will vote his real beliefs and see them in the right context. So I was a little bit depressed, but I think it was sort of, we were, on these opposite parts of the divide. I myself am more prone to go in the conservative direction. He was more prone to go in the liberal direction. And so we had, in some ways, it was a good debate because the students saw, real conflict here, just like they would see in the nomination process.
First of all, I think what really cooked Bork's goose was when he decided to tell the Senate committee that the 14th Amendment did not apply to females because the word used was men, not person. I mean, if you're going to be, that, on top of everything else, that one was just the icing on the cake. At that point, the Senate said, no. One of the things I think Will Craig said that they thought most Supreme Court justices were in their 40s were quite not true.
Were what?
Were in their 40s when they came to court, not true.
Not Supreme Court, I'm a justice. Don't you think justice?
No.
40s, 50s?
By and large, those people who go to the Supreme Court are in their 60s, primarily because we really don't want to have justices sitting for 30, 35 years. And John Marshall was there for 35 years, Stephen Justice Field for 36. These guys got so far divorced from reality in terms of what was going on in the country and those kinds of things, and the issues that were to be decided, that they were really becoming obstructionists almost to proceeding with any kind of government, and a government was able to deal with real problems. And Alito and Roberts, both in their 50s, are extremely young.
I thought now they might be.
They're extremely young for being appointed to court at all.
Okay, I will.
Yeah, part of the problem with that, what was it, William Millis, resigned from court in 96, David Field in 97. But, do we want these guys sitting there till they're 100? I mean, for Roberts, that could be like 47 years on the court.
Well, that's true, but in fact, I would say most justices do not last that long. But I actually think that it probably be a good idea that when a person reaches 80, they are officially retired from the court. But there's a certain cap, because we never know when people's physical ailments, mental ailments might get in the way, and some of those justices have had.
Yeah, this is clearly part of the problem. I mean, everybody thought Douglas should have gone years before he did, but there's simply no way to get rid of him. As you said, it's a lifetime appointment, and until they decide to resign, they're there. And almost everybody thought Douglas should have been gone a number of years. I mean, the man was falling asleep during oral arguments, and it got to be a joke almost.
If I recall the episode when FDR wanted to reform the Supreme Court, or patent, depending on your point of view, one of the big buggaboos at the time was there was no pension plan for Supreme Court justices. When they left the court, their salary stopped. And of course, he wanted to get them out by a certain age or put a helper on the court to take on part of the load. And of course, he failed to get it through Congress, but as a result of that, Congress did pass a law allowing Supreme Court justices to have a pension when they left the court. And then a number of the old guys who've been hanging on like grim death decided to take advantage of it, and then FDR got to appoint a number of justices to the court. So really, he did help, although at the time he was considered to be a dictator because he was going to try to pack the court. But I think it was probably a good move to give him a pension and encourage him to leave.
Well, that was one issue. He ultimately, because he was president for at least the start of the full term, that was a long period of time, 13 years or so, he ultimately got to nominate 8 justices. So he could really transform the court over time. But part of it is that Supreme Court justices, even though they are somewhat impervious, they're immune, aren't totally immune to what's going on in the body politic. They will see that Congress and the people and perhaps the president are upset, and then they might modify positions so that, although some of the New Deal legislation was declared unconstitutional, later versions then passed muster because they realized, well, this has aroused a tremendous opposition. And I think they're sensitive to the fact that their position in American political system is dependent on the goodwill and the support they have among the American people. That they're immune, yeah, but they're not totally immune from those political pressures. They're still there.
Ultimately, there's no way for the Supreme Court to enforce its own opinions and decisions. It depends on our goodwill. The school prayer case is monumental, unpopular decision. And pretty much people are ignoring it all over the country.
Unless they get charged in a lawsuit, which then might be really costly for the school system, and then the school system says, hey, we're caving in. You know? But you're right, it's up to then the president to enforce the law. And Congress actually does have the authority to, it's not used very often, to take certain kinds of issues out of the court's jurisdiction. But it's something that is almost never done because they realize that would be a very dangerous step.
Yeah, the Bush administration proposed taking trials of accused terrorist suspects out of the court's jurisdiction so that we have no place to go to take care of habeas corpus and other issues. And of course, Congress has not passed that, but this is one of the rare times when it's brought up. The Bush administration seems to have few compunctions about doing that sort of thing in the case of things that impact on the war on terror plans and programs.
Yep.
3 short questions. What are the qualifications needed for the justices? Why 9, and was Thurgood Marshall the first black justice?
Could you give me that second question again?
Why 9?
Why not?
Why 9?
Because Congress said so.
Yeah.
But why 9? I don't care why that they said so, but why did they say 9?
There have been 3, 5, and 9. It's whatever Congress decides. as long as it's odd. The
But
only
it has been
constitutional
9 for a
requirement is
long
I
time.
understand the odd part, but I just,
Well, it's been that way for a long time, and part of it is that if the court gets actually too big, it becomes less efficient, less workable. So one of the problems with FDR wanting to expand the court to 15 is that it's then much harder to reconcile opinions and coming out with clearing the court's agenda. I mean, they try not to take nearly every case anyway. The qualifications, you don't have to necessarily be a lawyer. Many of the Supreme Court justices were people with long political experience who had close connections with the president of the ruling party at the time, and they were appointed to that position. And part of it was that legal training was not absolutely necessary so long that you had a good understanding of the constitutional principles. I mean, after all, the American Constitution is a fairly short document. And it sketches out in very broad principles, and that you have a good sense of the role that law plays. That good judgment does not necessarily mean that you have to have a law degree. So that's not a requirement. I think there is an age requirement,
well...
but I'm not sure what it is right off the bat.
Okay, if the justices are supposed to rule on the Constitution, how do you fit abortion into that? How do you fit some of these cases that have come up that, you know, haven't been addressed by the Constitution?
Right. Now, Harry Blackmun, when he wrote the decision, he wrote the majority opinion on Roe v. Wade, which established that right to abortion, admitted that there is no specific statement in the Constitution that people have the right to privacy. But it's really the right to privacy that is at the root of his constitutional argument. And that right of privacy especially is connected with our own persons. That it is a long established right that was not articulated in the Constitution, but has been part of English common law and so forth from the beginning of our legal background. So that he made this argument that one of those rights of privacy is control over our own bodies. Okay? Now, one of the reasons why many scholars and, in fact, justices feel that this is a weak decision is that it is not rooted in any particular part of the Constitution directly. And so they say this is a right that, if it was granted, should have been granted by the legislature. It's not something that should be granted by the court. This is a place where the court went too far in how it could interpret the Constitution. But a liberal would say, well, back in those times that was not an issue. It is an issue in 21st century America. It was 20th century America. And it was a situation where courts and states were adopting a different position on that issue, and there was an attempt to sort of regularize. Some people would say that's better done in the legislature than it is in the court. But the court took on that case and made that decision.
One other question. The early fathers, what could they determine that the Supreme Court, these justices, could do to help the country? I mean, that had to be tremendous foresight, but I mean, what particularly, how would a case before the Supreme Court benefit the country, especially back then?
Well, there needs to be some way to determine how that Constitution is going to be applied, because that is the basic framework of how the political system works, how the government system works in its relationship to the people. So there has to be something, but actually it was the second Chief Justice, George Marshall, who played the most important role in shaping probably the position of the Supreme Court. He had big political problems with Thomas Jefferson. Many of the early leaders of what was then called the Republican Party that became the Democratic Party so names changed somewhat. So he was a Federalist himself. There were strong arguments that he had with the administration, and sometimes he'd make judgments and then the administration wouldn't enforce them, like we were talking about. But he led the court in a way of having the right to interpret legislation. The most famous case that I can remember of that was Marbury versus Nass. This was over I think the delivery of documents that would allow Marbury to take a court position in the court. But there were various other cases. And he was on the court for a long time. So he helped to shape the court to make it maybe the weakest of the three branches, but still one that could serve as the arbiter to say when Congress or the President stepped over the line.
Who was that husband?
George Marshall. John Marshall. Why am I thinking of George, the general?
I don't know, but I think he probably would have done it if he had the chance.
I think we have to remember that if we were going to strictly interpret the Constitution the way that it was written, that Clarence Thomas would probably still be a slave.
Well, except that the 14th and 15th Amendment came along, and that modified.
Yeah, it modified it, yeah. But
Yeah.
it wasn't there in the first place.
No, but that's now part of the Constitution.
Right.
So there is that process, which is very difficult to
Yeah.
change.
But if we followed strict stare decisis and they stuck with Plessy versus Ferguson, he still would have been on board because he would have been able to get the education that would put him there.
Yeah, that, and incidentally, are you familiar with this new 5-4 Supreme Court decision about school desegregation and some of the plans that had...
I can't say I know any of the details of that. I've heard that they made a decision, but I don't know.
Back to stuff.
Well, it's going to take us back to resegregation of the schools, there's no question about it, unless, something has changed.
I just want to make one quick comment. Okay, remember the Declaration of Independence? Where does it say our rights come from? We are endowed by our Creator with certain inalienable rights to life, liberty, and the pursuit of happiness. One view, very important of the Constitution, is that, and the whole judicial process, is that rights don't come from government. Rights don't come from legislatures. Rights are there, and if anybody's going to mess with them, they're going to have to justify them. And this is the thing ultimately behind Roe versus Wade. The rights to do with what you want with your body is there. Do state legislatures, whatever, have the right to mess with that? And
Well, that's part of the argument, but in fact, if you look at a case of abortion, you might say there are rights of not just one, depends on how you define it, but not just one individual, but two
well,
individuals.
legally, at that point in time, when Roe was written, you had to be a born, alive person to be a person under the law. An unborn was not considered to be a person, therefore had no independent right to exist. That's still being hashed out. That's part of what some of these other decisions are about. That impinge on Roe versus Wade is whether or not we wish to retain that definition.
Well, I'm not so sure that that definition is that clearly drawn. And one of the things that Roe v. Wade was set up, the 3-trimester system, which was, what do you think of,
Based on medical technology.
Yeah, medical technology
It made more
changes all
sense
the
than it
time.
does in 2007.
So people were looking at that and saying that that's a kind of issue that would have been better left to legislators to wrestle with over time. Now, there are some issues that legislators don't want to deal with, and they prefer that the court make the decision, but that's sort of an application maybe of their responsibility too.
One of the things we all mentioned, because I don't know whether everybody realizes it or not, the Supreme Court doesn't get cases just automatically. First of all, they have to be appealed from lower courts. And secondly, the Supreme Court gets to choose which ones they'll hear, which ones they won't.
They don't choose that many.
They don't, they get probably 1,800 requests or more a year. And they can hear maybe 150 of those. And that's a big workload because average Supreme Court justice reads about 60 to 65,000 pages of court documents just on those cases they read here every year. Huge workload there.
It's hard writing the opinions, and they talk about, one of the interesting things in the book, she talks about David Souter. And his first year, he was asked to write a majority opinion on a not very controversial case. And he just couldn't seem to get the opinion written, you know. And finally, the Chief Justice said, where is this document that you're supposed to circulate among us? It was that, he was just a methodical, slow worker. Now, he has picked up his pace considerably since then. But you can imagine if, you have one justice working on one case for the whole year, there's not going to be many decisions. But they work pretty hard.
It's a famous quote, and I'm trying to remember whether it was Oliver Wendell Holmes Jr. that said it, about the Constitution is not a suicide pact. Was it he that said that?
You've got me. I
Someone
don't know that.
But they were referring to this, whether you go with strict interpretation, at least it said the Constitution is not a suicide pact.
Even the most strict interpreters of the Constitution, people like Scalia and Thomas, though, are more flexible than they have been charged to be. And those who want a more liberal interpretation are not as loose with the Constitution as their critics usually charge. They're closer in than that. I mean, part of it is these cases are all really complex. I mean, the last case that I looked at in detail and talked about in public was the Kilo case about property and that sort of thing. And I read the interpretations and everything, and I read first the ones that were opposed to the case because that was where my orientation was, and still is. But then after doing that, I said, well, okay, in justice, I have to read the ones in the majority opinion. And I was going through and I realized, well, they also have some very strong arguments and considerations that can be made because the public good can benefit sometimes from those kind of decisions. So even cases that seem, easy on the surface have dimensions and consequences that sometimes they can't fully see, or we can't see until later.
Yeah, like the decision that put Bush in the presidency. That sure had some consequences, didn't it?
Well, it did, but if you take it away from the Supreme Court, from what I've heard when they did the actual recount, he would have got it anyway. From what I've heard. Now, there are people who still question that, but in the recount that they did in Florida, it indicates that he might still have been elected. Now, if they had counted all the ballots, then mid-court might have been. It was a very controversial thing, and you're right. Those decisions have consequences. Then once the decision's made, you can't go back. But that probably is not a decision that's not going to hang around in the same way as a constitutional decision like the Kilo case. Because if it's once possible to seize people of property for the good of the community, even if the state passes laws that try to protect your private property, those laws do not have constitutional protection anymore. They can be changed by a state legislator in the next big development that will come along and say, let's slay the legislation and weaken that.
I think the other thing we have to realize is that we have so many treaties and international agreements on trade and defense and all manner of other things that increasingly impinge on what the courts must consider, because all of those treaties have the same force and effect of laws passed by Congress. And the Supreme Court gets criticized a lot, I think, for making references to international laws and things like this. We're bound by law and by our own agreements and treaties to abide by these things, so we do have to account for them.
Yeah.
Yeah, I know they're taking a big hit from some, especially radio talk show commentators for mentioning these kind of things. But go back and read some of John Jay was my first Chief Justice. Jay's decisions, even Marshall's and many of the early Supreme Court decisions refer to foreign laws. Because at the time we had so few, the principles were mostly embodied in English and French law. And so they refer to them all the time anyway. But this is something that is increasingly complex because so many decisions impinge on what businesses can do or foreign businesses can do here, we can do abroad, other kinds of things like that. It's getting to be a really complex situation.
So let Dr. Laker open it up. We have one final question. Thank you, Dr. Laker.
My pleasure.
Yodeling Dick here to tell you about a happening. Lunch with books. Lunch with books, that's Coxie, Coxie, Haxie, Fraxie, yells and sings, rocks and snaps, more and more. Lunch with books. Lunch with books. At the Ohio County Public Library in Wheeling, West Virginia. It'll make you feel like yodeling. Hey, yodie, 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 hey, yodie, yodie, mostly on Tuesdays at noon. Bring your lunch, we'll provide the pot. And it's all free. Lunch with books. Knowledge is served.